Education 571 for St. Martin's University, Week 1. This is entitled Introduction and Contracts. It will discuss basic civics and the dual system of state and federal law. First, very briefly, let's discuss the sources of law and the hierarchy of law. At the top of the hierarchy are the constitutions, with the U.S. Constitution being preeminent. And then every state has a constitution. Understand that the structure of the Constitution sets up the government into three branches: legislative, executive, and judicial. And what's important for our purposes is that the constitutions include either a Bill of Rights, as in the federal Constitution, or a Declaration of Rights, as in our state Constitution. This is important because they are protections against state or government action. So when someone claims that their constitutional rights have been violated, there has to be some state actor or government action interfering with your right to free speech, etc. This is germane for teachers because if you're a public school teacher, you have constitutional rights, whereas private school teachers generally do not have constitutional rights vis-a-vis the administration. The other point to remember is that in the whole scheme of things, if federal law is supreme, if provided that Congress has acted within its enumerated power, such as in exercising its power over interstate commerce, over foreign affairs, things like that. You'll notice that in the 10th Amendment to the federal Constitution leaves everything else to the states and the people. And in that regard, the states have broad power, what's called police power, to regulate for public peace, health, or safety. The second source of law are statutes. In the United States, we have the U.S. Code for Congress, for the federal level, and at the state level, in the state of Washington, we refer to these as RCWs, or the Revised Code of Washington. Beneath that are administrative regulations. In the United States, we have the Code of Federal Regulations, that's for the federal government, and in the state of Washington, we have what are called WACs, or Washington Administrative Code. Finally, we have a thing called common law at both the state and federal level. These are court-made at the federal level decisions that elaborate on the enumerated areas of bankruptcy, interstate commerce, civil rights, antitrust, and things like that are specifically enumerated that the federal Constitution gives to Congress to regulate. In the state, the states have more general power, authority, and these are the primary sources for what are called torts and contract law. We're going to torts, but let me talk about contracts. There are four elements of contracts that you're aware of. First is the agreements, the offer and acceptance, and generally in common law contracts you have to have fairly terms. Price is a very important term. This is, for an acceptance, can be best considered as a means that both parties have to know what they're talking about. An element is called or a bargain for exchange. This is typically money. It can be forbearance. You gave up something to enter into this agreement. The third element is capacity. Typically this refers to age and mental capabilities, but can also, if the person has authority to sign off on a contract. This is germane for teachers because under most circumstances only the board can approve of a contract. Next issue is legality, and obviously a contract can't violate state or federal law and can't, it's called public policy. Now, one of the things I want to end with you, a contract can be oral or written, still be valid. Certain contracts in writing to be valid. For example, a contract that cannot be performed within 1 year. Let's say you have a 3-year teaching contract that needs to be in writing to be valid. If it's not in writing, it doesn't mean you're out of luck. There are certain remedies that are available to you that are discussed in the book but generally the remedies available for a breach of contract are legal remedies which come under a variety of names like compensatory damages, liquidated damages, things like that. And then remedies, which injunctions and specific performance. Let me address the dual court system which is raised in chapter 1 of your book. There's a federal and state court system. Both are dependent on this term jurisdiction, which means the power of a particular court to decide the issue, and the power of a particular court and individual. That's the term jurisdiction. Venue is the question of determine what level of court has the power to hear this dispute. Where you go, what court? In the state of Washington, if you had a federal, which can be based on a federal question or what's called a citizen over 75,000 in dispute, there are 2 federal district courts in the state of Washington, one for the western Washington, the other for eastern Washington, and venue would be where would you go, and that normally is dependent on where the defendant resides. Now, both federal and state courts have a parallel structure. They basically levels. First is the courts of limited jurisdiction. These are courts that have limited power over a specific area of law, a finite amount in controversy. For example, in the federal system, the bankruptcy is a court of limited jurisdiction. In the states, you have, for example, this court, they have authority over under a certain amount of money. The courts of general jurisdiction are normally where all the action takes place, and these are, in the federal system, referred to as the federal district courts. State system, they go under different names. State of Washington, we call them superior courts. You get one appeal as a matter of right, 2 levels of appeal. Typically, most appeals go to the immediate next level, and the federal circuit, and the states referred to as the Court of Appeals. The next level is the the federal U.S. Supreme Court, obviously, and state Supreme Court. Again, it's important to remember that you don't have a right to go to the Supreme Court. There are some rare exceptions to that, but generally having a case heard by a state or federal Supreme Court is discretionary by the court. You have to meet certain criteria. Let me briefly address civil procedure, how a civil case gets going. You would file and serve what's called a summons and complaint. Then the other party can answer it. They can counterclaims. They can bring other parties in, which is called cross claims. You would then get the opportunity to reply. Then you go through what's called motion practice or discovery, which includes things like interrogatories, questions you can ask people, production of documents, things like that. There are motions that can be done. The key motions are motions to dismiss and motion for summary judgment. Summary judgment is the most important motion to know, and that's just a motion which basically says there are no factual, material facts in dispute. The only issue is how the law of the facts, and you go to the judge and say, make a decision based on basically the stipulated facts. If you can't get a case knocked out at motions, you go to trial. It can be a bench trial before a judge or a jury, and then after the trial, post-trial, there are motions, and then if you can still appeal after that, so it's a very time-consuming process. Therefore, the last thing I want to talk about fairly is what's called ADR, or Alternative Dispute Resolution. This is a very popular in contracts to insist on arbitration or mediation. It avoids the cost, time, and stress of civil litigation. And so that's our summary for chapters 1 and 2.